Module Overview. This module delves into the legal, ethical, and technical complexities of transferring personal health data across borders. In an age of international research, telemedicine, AI-driven health analytics, and cloud computing, healthcare providers and data controllers must understand the regulatory requirements, risks, and mitigation strategies involved in transferring sensitive health data internationally. With the globalization of healthcare services, multinational research studies, and outsourced IT infrastructure, e.g. cloud servers hosted abroad, the movement of patient data across national borders is both inevitable and controversial. This module addresses how international data transfers are regulated under GDPR, Chapter 5, Articles 44 to 50, UK GDPR and the UK Data Protection Act, 2018, HIPAA, USA, plus High-Tech Act, FIPA, Canada. OECD Guidelines, ISO/IEC 27701, International Privacy Management. It also explores data adequacy decisions, standard contractual clauses, binding corporate rules, data transfer impact assessments (DTIAS), and legal interoperability challenges between conflicting national privacy regimes. 1. Why cross-border data transfers occur in healthcare. Common use cases: international patient referrals or treatments, e.g. UK NHS referring to EU specialists, cloud-based EHR storage, e.g. servers in the US or India, outsourced transcription or imaging services, international clinical trials and health research telemedicine services crossing regional or national borders. Use of AI tools hosted on non-EU servers. Risks: loss of jurisdictional protection, non-compliance with local data protection laws, lack of legal recourse for patients, government surveillance or seizure in destination country. 2. Legal foundations under GDPR, EU and UK. GDPR Chapter 5, Articles 44 to 50 governs international data transfers and applies to both data controllers and processors. Legal options for transfers. Adequacy decisions, Article 45, permits transfer to countries deemed to have adequate protection, e.g. Canada, Japan, Israel, UK post-Brexit, Switzerland. No need for additional safeguards. Standard contractual clauses, SCCS, Article 46. Template legal agreements adopted by the EU Commission. Mandatory when no adequacy exists, e.g. transfers to India, US-based platforms. Must be supplemented by technical safeguards. Binding corporate rules, BCRS, used by multinational corporations to govern internal data flows. Require approval from supervisory authorities. Derogations for specific situations, Article 49. Explicit consent from data subject vital interest of individual legal claims or international cooperation. 3. HIPAA and FIPA comparison. HIPAA, USA, does not restrict data transfers abroad, but requires business associate agreements, BAAs. Exported PHI must be protected under equivalent safeguards. Patients retain rights over data usage. PHIPA, Ontario, Canada, allows cross-border transfers with contractual and organizational safeguards. Requires disclosure in privacy policies. Mandates notification if the destination country has lower privacy standards. 4. Emerging mechanisms and challenges. Data transfer impact assessments, DTIAs. Required to evaluate legal risks in the recipient country, e.g., risk of U.S. surveillance under FISA. Evaluates the enforceability of contract clauses. Schrems II ruling invalidated the US-EU Privacy Shield. Emphasized the need for supplementary measures, encryption, anonymization, and strong oversight. Legal interoperability challenges. Conflicting standards between GDPR versus HIPAA versus local laws. Restrictions on data localization in some countries. Inequities in access to legal remedies for foreign patients. 5. Technical and organizational safeguards. Technical, end-to-end encryption, data masking or pseudonymization, geofencing of health data storage, differential privacy for data analytics. Organizational, staff training. Internal audit trails. Privacy by default architecture, pre-transfer data, minimization, and necessity testing. 6. Ethical considerations in cross-border transfers. Transparency, informing data subjects where their data is going. Consent, especially for non-essential data transfers. Justice, avoiding exploitation of countries with weak privacy laws. Equity, ensuring foreign patients have equal protection rights. 7. Case study, telehealth services in the UK using US-based providers. A UK NHS clinic uses a US video conferencing tool, e.g. Zoom or Doxy.me. Video sessions and EHR data flow to servers in the US. DTIA conducted shows risk under FISA. Supplementary encryption added. SCCS signed. Patients are informed and consent is recorded. ICO reviews and confirms the transfer model is compliant. Accreditation alignment. GDPR. Chapter 5 Compliance. Article 44 to 50. HIPAA and FIPA interoperability ISO/IEC 27701 Data Privacy Framework. CPD, DPO, and Medical Ethics Training Accreditation compatible. Incorporates real-world case examples, critical analysis, and technical plus legal fusion. Suitable for level 5 to 6 on UK RQF or postgrad short course equivalency,